Good morning, everyone, and welcome to today's ECA Coronavirus Impact webinar. Today's topic is Managing Commercial and Contractual Challenges. We'll be discussing the CLC's recently published Roadmap to Recovery, taking a closer look at the impact COVID-19 has had on the construction sector and contractual best practice, and much more. Our panelists today are Anne Bentley and Ruth Wilkinson. Anne Bentley is a Global Board Director of Levett, Bucknall, a QS, PM and advisory firm. Anne is a member of the UK Government's Construction Leadership Council and an advisor to the Construction Industry Council. With a 35-year track record in the property and construction sector, Anne is experienced in working with commercial, public and third sector clients with particular expertise in estate renewal and community development. Ruth Wilkinson is a partner of Clarkslegal in the construction and engineering group. Ruth has over 10 years experience in construction and engineering, advising on both construction disputes and front-end contract advisory work, acting on behalf of employers, developers, contractors, specialist subcontractors, and professional consultants. Hosting today's discussion is Rob Driscoll, ECA's Director of Legal and Business. Now, before I hand over to Rob, just a reminder that you can ask a question at any time using the Q&A box on your screen. Our panelists will be answering as many of your questions as possible at the end of this webinar. And finally, viewers are reminded that a replay of today's session, as well as replays of the entire ECA webinar series, are available on ECA's YouTube channel at youtube.com/ECA Live. For more information and guidance and a wealth of materials related to business recovery, please visit eca.co.uk/business-recovery. We hope you enjoy the session. Over to you, Rob.
Good morning, everybody, and welcome to the session. We just wanted to set the scene as to what's happened in terms of the economy. We moved out of March crisis management phase. What did lockdown look like? What was going to happen to the economy? And as we moved into April, the OBR, which is the Office of Budgetary Responsibility, you'll have seen on previous webinars, came up with this graph on the far right, is the nature of the crash they expected in one model. I use the word model because economists are pretty much refusing to forecast anything at the moment, simply because there are so many variables, such a fast-moving environment, they don't know what things look like. At the start of April, this was expected to be an extreme V crash, which would bounce back to normal with a vengeance. And that was because we didn't know what the ongoing consequences on productivity, site safety would look like. You also see there that they predicted a huge drop in construction activity, which is a cornerstone of the UK economy. Other figures have centred around the 100 billion-ish mark for the contribution construction makes to UK economy, with a further, I think it's 122 billion to FM and infrastructure. But they combined, they enable the wider society to contribute something like £540 billion worth of contribution. So construction is key. It may not always reach the headlines in terms of the mainstream media, but is key to recovery. So that was the start of April, but where do we go next? We're now in June, and it's still a very different picture. As day by day, politicians make announcements about opening up the economy, but simultaneously making announcements about how well or not so well we're doing with managing the virus infection rate themselves. Just another couple of figures in terms of construction per se. CPA, which is the Construction Products Association, who are, I would say, the leading economists in our industry and do a lot of work for Treasury and Office of National Statistics in this area, predicted a 25% crash in the UK construction economy. Construction line there, you'll see that 47% reduced activity by over 80%. And then we saw FMB, which I think from memory has around 6,000 members, saw that 68% of builders stopped 91% of their projects during April. So that was a huge decline in construction activity across the economy. The Builders Merchants Federation there at the bottom saw a 6.7 reduction in sales. I think there is a distinction here for the electrotechnical and the M&E sector, where some of the large aggregate suppliers stopped activity and closed production and sales, which may account for that. The headlines in media were around reduced supplies, whereas we know from our sector that supplies continue to be available because they're of a different nature. So to take us into how we climb out of this crash and what it looks like, and Bentley.
Thanks very much, Rob, and thanks for inviting me to talk to you today. Oh dear, the slides look slightly, let's hope the next one's a bit better. Perhaps you could flip quickly onto the next slide for me. Okay, so as the introduction said, I sit on the Construction Leadership Council, and one of the things that the Construction Leadership Council has been doing since we entered the coronavirus crisis is really trying to act as a focal point for the industry. It's fair to say that the CLC has always had some of the ear of government, but what the crisis has done has made it very clear that the government only really wants to talk to a small number of organisations. And so having a construction council means that the government do see that as an important body to talk to. And so, although the recovery plan is the work of the CLC, it has been through the ministerial checking process, which any sort of policy document would have to go through. And that does give it a certain status. It doesn't mean that the government necessarily agree with every line of the plan, but it certainly means that they don't disagree with this either. And, you know, I think that is actually probably as good as an endorsement we're going to get. Why do we need a strategy? Well, as Rob said, you know, the figures show that the decline has been very drastic, and what the fear is that the recovery could be slow. You know, there are a lot of different forecasts out there at the moment in terms of whether we're going to have a V-shaped downturn or a U-shaped downturn or whatever. But I think it's fair to say that current indications now suggest that it's going to run certainly into next year and possibly even into the year after. And so there is a feeling across the entire construction sector that we need to pull together, we need to do something now, we need to get government endorsement for some of the plans. Perhaps if you want to go on to the next slide, Rob. This is really very much a repeat of what Rob showed. You know, we've seen how steep the decline has been, and then the next slide, hopefully, will show us one of the views, at least, of what the recovery might be. So this, again, is taken from the CPA's forecast, but it's based on Office of National Statistics information, at least historically, and obviously it's the CPA forecast going forward. What you'll see from that is almost a combination of the sort of the U and the V. So it shows a relatively quick upturn for the first couple of months, and I can see how that would happen because there will have been some pent-up demand, but then a slower recovery maybe over the next 1 or even 2 years. And really where we are at the moment is in the situation where we want construction to be in the best possible place to make this as fast as it can be. So if we go on to the next slide, Rob. The Construction Leadership Council has been in existence for some time, and the fundamental purpose of the CLC is to, I guess, 2 things. One is to act as a sort of bridge between the construction industry and government. But secondly, it's to actually deliver some specific objectives that were set out in the construction strategy some years ago now. And that's about productivity, it's about lowering costs, lowering carbon, delivering things faster and improving exports. And that's not just for the sake of saving money, it's so that we actually can create more capacity, more houses, etc. And In the last couple of years or so, last 2 or 3 years, I suppose, since the industrial strategy has been in place, the CLC has very much been focusing in 3 specific areas, which is the digitisation and the impact of digital technologies on the construction industry, the impact of manufacturing in all its guises, so off-site manufacturing, on-site manufacturing, etc., and also performance of the assets themselves. And originally that was then broken down into a number of work streams. These are the sort of things going, if you like, horizontally across the slide. Since the coronavirus has really impacted on the industry, these work streams have been both expanded, but also their purpose has been refined somewhat. And so we've now really crystallized on these key work streams. So procurement and value, people and skills, building safety, net zero and carbon, innovation, and fair payment. And if we move on to the next slide, Rob, what we'll see is that we've had to, if you like, overlay those work streams with what we think is absolutely imperative in terms of where the industry currently is and where the industry needs to get to. So the plan itself is in 3 specific parts. It's restart, i.e. how do we actually get people back to work? And to be fair, much of that plan is already in train now. It's reset, so what do we have to do in the sort of medium term to actually make sure there is work for us to do? And possibly the most interesting part of it is the reinvent, and it's the reinvent that very much ties in with the CLC's original strategy, which is where is the industry going, what should we be doing in the future, how can we actually maintain productivity, how can we be an effective industry in a changing marketplace. But one of the things that has always been there, but is probably even more to the fore at the moment, is construction isn't, you know, a homogenous industry. Construction has lots and lots of different parts. And it was felt by the CLC that if we were going to produce a meaningful plan, we had to recognise that different parts of the construction industry have different demands, they have different cycles, they have different ways of working. And so the recovery plan is very much split up into infrastructure, housing, renewals, maintenance and improvements, and sort of local social and commercial construction. And each one of those will be dealt with in a slightly different way. So if we go on to the next slide, Rob, what this shows is some of the sort of highlights of the different phases of the plan. So phase 1, restart, 3 months, but given that this was actually written probably a month ago, if I'm honest. So this is really, you know, how do we get people back working on site, and how do we actually make sure that what is happening on site is consistent with government guidance? Because, you know, it will be possible to get jobs up and running, but actually they have to be up and running safely, clearly, and that has to be everyone's priority. The second part of it, and I think that it's fair to say that that part is pretty much there now, you know, with the safe operating procedures, the site operating procedures. What's being looked at the moment is then how do we maximise employment, or at least minimise unemployment, I guess, depending which side of the coin you're looking at. And that again is looking right across industry and across its supply chain. Are there opportunities, for example, for companies to swap labour, to borrow labour, to set up a sort of labour exchange portal for the construction industry, etc. And also, are there things that government could do to sustain employment in the industry as well? And then the final bit in this first phase, minimise disruption due to contractual disputes. Clearly, Rob already mentioned the government has published quite a lot of guidance on this. The CLC has published guidance on this, and I know quite a lot of today's conversation is going to focus on that. So if we go into the next slide, Rob, this then sets out really the middle stage of the recovery plan. And this is, again, in 3 parts. It's about, first of all, creating and quantifying demand. The thing that I think most people in the industry are worried about now is not so much how do we get sites up and running, because I think that's now well established. It's much more about what will the workload be in the next 3, 6, 9 months. And clearly there's two elements to this. There's the work that's already planned, and can we capture that, and can we actually see those plans so that we can, as an industry, actually make our plans align with that pipeline. But also there's the really, really important side of it, which is about economic stimulus that actually could promote demand or even brings demand forward, you know, particularly in the public sector. And again, the CLC would see this as one of our primary roles, which is to really encourage some of these public sector schemes to be brought forward, to be given the go-ahead, to make sure that we actually are getting the work at the right time, so, and therefore avoiding any necessity to sort of downsize the industry, if you like, which is a real concern. The second part of the medium-term plan is productivity, that there is absolutely no question from a government point of view that government is keen to help the industry, but it sees that the industry must help itself. And one of government's complaints about the industry way before we were hit by coronavirus was it is simply an inefficient and unproductive industry compared to other industries. And so, if you like, you know, if one side of the coin is can government promote demand or you know, put forward economic stimuli, then the other side of the coin is that has to be met by a more productive industry. The final part of the medium phase is making sure we've actually got the industry that is fit to go into the final stage of the plan. And, you know, the word that's been coined here is professionalism. Actually making sure that we're not just historically trained, but we're trained for the industry that we're going to enter, that we understand collaborative business models, that we understand fair contracts, we understand payment mechanisms. And so a huge bit of both industry and government effort is being put into retraining, educating, making sure that all of us, and this isn't just about consultants, this is across the whole industry, is actually prepared for the next phase. And if we go on to the next slide, Rob, what this one really shows us then is where we think we could get to in 12 months plus. And this one I think is very aspirational, but that in itself isn't a reason not to do it. I think it's great to be aspirational. And that's saying, you know, if we really want to sustain economic growth, both throughout construction but through the wider economy, we have got to adopt digital technologies. We've got to adopt more manufacturing. And we've got to deliver consistent quality, and we've got to be in a low carbon environment. So there's some really, really big challenges. The bit that any of you who know me will know is very close to my heart is that the only way we can do some of this transformation is by completely redefining value and adopting procurement models and approaches where clients can assess the value not just in terms of capital costs, but in terms of whole life performance, in terms of social value, in terms of the carbon agenda, etc. And there's quite a lot of work being done in that area at the moment, which will stand us in good stead for this sort of 12 months hence, if you like. And the final sort of part of this part of the plan is that this will only work if we have these much, much stronger partnerships, you know, sort of vertical partnerships, if you like, from client through the designers, through the contractors, through the whole supply chain. And stronger in terms of delivery, but also stronger in terms of upskilling the workforce. So, you know, we're not left with tens of thousands, if not millions of SMEs that sort of doing the work, but not actually being upskilled to meet that transformational agenda. So some great aspirations. And how is the CLC going to pull this together? Well, if we go on to the next slide, Rob, the CLC's sort of objectives here are really to act very much as I guess a convening group, first of all, and I think, you know, that what we've been able to do in the last few weeks has shown that we do have the ear of government to a very great extent, actually. So first of all, it's to convene, it's to pull together proposals to mean that instead of lots and lots of different organisations going to government with lots of different requests, we act as a sort of mouthpiece, which means our chance for funding is much greater. It means that our proposals will be looked at much more seriously by government. So first of all, you know, it's to be a convener, it's to be a presenter, it's to be a mouthpiece. But what we do understand is if we are actually going to do that, then the CLC itself may need to reform, and we're already looking at how we can widen the CLC's engagement. I mean, again, the recovery plan has been contributed to by huge numbers of trade associations, professional bodies, etc., and that has proved to be an incredibly powerful working group. And so part of the CLC's reforms are using the lessons that we've learned during the crisis to actually make the CLC a much more productive and much more effective group. And obviously, you know, assuming that the industry recovery plan sort of gets through its first phase, which I think it's doing pretty well on, actually. You know, the very first part of it is now very much in train. Then clearly it needs constant review, it needs reshaping, and it needs that continued focus. And part of the focus will be that BEIS, the Department for Business, Energy and Industrial Strategy, are actually providing some sort of project management and secretarial support to actually ensure that this isn't just a plan that's written and that is put into the drawer, if you like. It's a plan that will be interrogated, reviewed, and progress will be reported again. So I'm very hopeful that actually, you know, it's a terrible crisis. We've suffered terrible consequences, but there is a credible plan to take us forward. So thanks, Rob, for the time for the presentation.
Thank you very much, Ed. And guess you'll hang around and help us with some Q&A at the end.
Yeah.
So Ruth and I will take you and give you a little bit of a recap. We last spoke to you, I think it was the end of March, beginning of April, around some of the commercial and contractual issues. A lot's happened since then, and you'll see some of that contextualised in Anne's presentation about avoiding disputes and how to manage claims, etc. So I'll press on. You've seen some of these slides before, and that's because I wanted to take you and remind you of the messages we were getting from members. The first thing we were being told was there was a lot of subcontractor bullying. I can say this in terms of our political perspective, but people were being, at the start of the lockdown period, screamed at on site, you will carry on and you won't breach your contract or else. And then on the other side, they had some employees very nervous and apprehensive about continued site safety. And what we saw there was SOP, Site Operating Procedures, emerge. We've got version 1, 2, 3, and now 4, coupled with what was Public Health England guidance, and has now been COVID secure working safety guidance. And for our industry, there is a homes version, a manufacturing version, a construction and other outdoor areas version, and a travelling one as well, as well as offices. So what we said to you hasn't changed. Collaborate, confirm that you will abide by your contract, leverage your contractual position at the same time. In other words, make sure you know the clauses inside out, issue the notices on time in the right form as required by the contract. Maybe require them to confirm, especially where you are a subcontractor, require the main contractor to confirm they are fully able to comply with CLC position on site safety. And that included 4 elements. So that was travel to and from work safely. That was Public Health England guidance, which is now, as I say, the COVID secure government guidance. The SOP, which is relevant at the time. Now, each site operating procedures will be relevant during the period for which it was applicable. and multiple versions have been issued because the situation evolved. But that did create a slight complication with version 2, which only went live for about 3 hours before it was retracted back in favour of version 1. And then when 3 came out, they're all on our website, and we do highlight the dates they were released, as well as being available, obviously, on the CRC's website itself. But it's important because when you build a claim or a position up contractually, it will need to be relevant and related to the applicable circumstances, which in terms of SOP, you'll need to pin in the dates. Take pictures and evidence to support your position. Evidence and record keeping is an ongoing theme, and I don't think Ruth and I can make too much out of that issue. So I'm going to run you through what's come out of government and CLC in terms of payment and disputes. So 11th of March, I put lockdown then because I saw a lot of sites and offices in London and elsewhere starting to lock down prior to the official lockdown dates. Construction obviously continued, although clients may have suspended their site activities, but on a holistic level, construction continued. On March 15th, PPN 01/20, that's a policy procurement note, which is a government guidance as to how to do things. So it's telling itself, its constituent parts or procurement authorities, whether it be local authorities, schools, hospitals, MOD, or whatever else, it applies to nearly all procurement authorities in the public sector. And it was saying, look, we're suspending the procurement rules. Just get things done so we can cope with the COVID situation. That's broadly the message. Obviously, you need to read it in detail, and we have a guidance note on our website. On the 20th of March, PPN 02/20. Now, that was really important. That was about supply relief. That actually said, in order to stabilise your supply chains, public sector procurement authorities should look at various techniques for doing so. And that could include advanced payments, release of retentions, waiving certain clauses. Subsequent to that, you'll see that there was a PPN 02/20 construction guidance. It's been reissued a couple of times. That's translating the main PPN 02/20 into construction. The first issue of that guidance didn't really holistically cover the FM sector, but because of our roots into government, we were able to feed that back and they can improve it. What we're grateful for is that government did these things at incredibly breakneck speed to help support procurement and payment right across the economy. And I've seen members use those guidance notes to their advantage. And I'll touch a bit later on how you use these guidance, if they are any guidance. On the 8th of April, CLC came out with a statement on payments and contracts, and it was really the central message and ethos was, look guys, play nice, because the only thing that's going to suffer, the only people that are going to benefit in this, I'm going to say this as a solicitor, are the lawyers, and the only things that are going to suffer are both parties in project delivery. So the temptation to resort to traditional adversarial behaviours doesn't help anybody here. Then on May 7th, 2 things were released. The first was Cabinet Office guidance on responsible contractual behaviour. The second was the CLC's response, translating that guidance into how to have responsible contractual behaviour in the construction industry. So the Cabinet Office guidance, it is only guidance, doesn't cover the devolved territories, does cover or is aimed at both private as well as public sector, whereas those PPNs I mentioned are only applicable to public sector authorities that they cover. I guess footnote to that is ones that don't tend to cover things like national security issues tend to get excluded from those kind of things. It was immediate effect until the end of June, so it was to cover the initial lockdown period. It complements existing arrangements. In other words, it wasn't there to override anything. But what its objectives were to protect health, jobs, and the economy, ensuring cash flow, wages, and the supply chain in terms of stability and its ability to recover. This is all about the ability of the economy and the people in it to cover, to ensure business survival. So it was there to avoid disputes and insolvencies in terms of the cliff edge. And on the right there, you can see that I've kind of taken a couple of quotes out of the guidance itself, asking people to be reasonable and proportionate in the act in the spirit of cooperation and to achieve practical, just and equitable outcomes in terms of the negotiations. How useful is that? Well, it'd be interesting to see Ruth's perspective in a second as a private practice solicitor who will deal with both non-contentious as well as disputes. She'll be able to give us a kind of temperature test of how it's going out there in the wider world, in the legal landscape. The Cabinet Office guidance goes on to talk about its scope, that it applies to all of commerce, not just construction, but it does specifically mention the construction industry. It talks about how contracts might need to be adjusted in terms of their scope, their delivery, the ability of people to perform if their performance is impaired due to the impact of COVID-19. Payment and performance mechanisms might need to be adjusted, time and money issues, LADs, which are obviously clauses which try to represent the loss one party will suffer if there's delay. We talked, the note talks about suspension and termination rights as well. So it became, I think it's in section 13 or 14 of the note, a shopping list of issues which parties should have a grown-up conversation about. And then it talked about how consents, variations, notices, records, and agreements should be kept about how contracts might need to be adjusted to accommodate the impact of COVID-19 and ensure both parties can continue work and in some way accommodating that risk. It wouldn't be worth its weight unless it mentioned how you deal with disputes or enforcement, and it really makes a plea to the parties to use proportionate dispute resolution where it has to be used and a suitable result can't be achieved through negotiation and settlement. What it does interestingly mention is that if at the end of June this hadn't worked in encouraging the right behaviour in the business community, further measures would be considered. But so that's the government plea, if you like, the call to arms to all areas of commerce. Then the CLC responded, and my message is that their response was really centres around hope for the best and prepare for the worst in many ways. Hope for the best because the default shouldn't be adversarial behaviour. It's very easy to go there. And a slur on my own profession, it's very hard for lawyers to not default to aggressive protectionist behaviour. But the way to instruct your lawyers is to tell them exactly how you think we should negotiate. Obviously heed their advice, but know that they will default to their position because they don't want to avoid or breach their PI insurance. But if a client tells you as a solicitor or any other kind of lawyer how they want to proceed, those are the instructions we adhere to. So if a progressive client says no, weighed up the costs of all this and I want you to negotiate, then despite the risks, that's what we do. But so the CLC work talks about having concurrent conversations. So have your contractual conversation where you, in a fairly emotionless way, operate the contractual machinery, but also have your commercial dialogue, the settlement conversation simultaneously to see whether you can reach a position that both parties can accommodate and take. I won't say a happy or satisfactory outcome, because rarely, and I say this as a qualified mediator, the parties walk away feeling in any way actually happy, but it's a position they can accommodate commercially, even if it hurts. So pleased to say that thanks to ECA's contributions to the CLC's task force there, this particular work stream was led by the ECA CEO. We have 3 specialist private practice lawyers who had a specific interest with contractors, consultants, and public and private sector. We have public and private sector clients involved. So it came from all areas of the construction industry and the FM world. We took on board the views of funders, developers, purchasers, tenants in doing so as well as consultants. The CLC, looking at the media interest since, has been described as a pragmatic walkthrough to how to have the conversation. But it does focus on record keeping, how to making sure you operate your notices. In some of our earlier webinars, we did ask you, please don't, in a crisis or panic, have these conversations by WhatsApp or Facebook Messenger or anything else like that. They had been done. It's much harder to use that as evidence in supporting your negotiating position. So we said that the guidance asks you to continue to manage your projects, to have open book conversations. Parties shouldn't be looking to recover costs under the contract if, for example, they've already been reimbursed those costs under the government's coronavirus job retention system, which involves furloughing of employees. Parties might want to revise specifications. If there are particular products which both parties know is currently unavailable, why not try to source something else which will be equally appropriate? But if the original spec was drafted that narrowly, it might need to be amended. It also outlines some considerations the parties can think about when it comes to payment, the frequency, whether a project bank account is appropriate, whether advance payment is appropriate to ensure that materials can be available, isolated and ready to go when they're needed. And maybe actually one suggestion in terms of considerations is how you price the contract could be changed. Target cost is that mechanism where instead of lump sum or fixed price, you agree to share the gain or the pain in this case of going over the original estimated price. Again, the guidance notes talks about changing termination triggers, and it explains what without prejudice subject to contract means. We're aware that a lot of it becomes legalese, unnavigable, and the thought of then going and hiring a hired gun lawyer to protect you or to help you through this may become cost disproportionate. But this is trying to be helpful. So in the annexes, it's got a number of templates. The 1 and 2 letters are how to open the dialogue in a fairly conducive way. 3 focuses on a JCT and 4 NEC. Again, they're for use by various contractors, consultants. Obviously, templates need to be adapted. The number of times we've seen, not just within ECA, in all of my career, people failing to completely adapt the letter to suit their contracts, their projects, their names and details. Make sure you get it right before it goes, and make sure it's sent by the right method of communication. You don't really want arguments about, well, it wasn't validly sent, served, or anything else. Then the CLC guidance also touches on dispute resolution, and it spot checks the dispute resolution pledge and the low-cost adjudication service. The pledge ECA are signatories to, and that's about having a dispute management board on usually suitable for slightly larger projects, but the low-cost adjudication system allows people to take their disputes through a process where they know the costs are fairly fixed and manageable. So the cost of dispute resolution doesn't start to outweigh the value of the dispute. Ruth, I wondered whether you could come in here and help me out with your views on how this is going down.
In terms of can you hear me now?
Yeah.
Oh, excellent. And in terms of the kind of reaction today, I think in all honesty, I've not seen it have much traction on any of the matters that I have been dealing with, and certainly from speaking to other private practice solicitors, and I've been trying to reach out to a few more. The impression that I'm getting is pretty much as you outlined, that solicitors, lawyers will continue to revert back to their kind of protectionist stance of sticking to the contract, and need that guidance from their clients, particularly if they want to go down a different route, if they want to enter into without prejudice negotiations. Now, from my personal standpoint, and this is the stance that I've always taken on matters, regardless of whether before COVID-19, is to kind of right at the outset of a set of instructions to take a steer on the kind of the merits of the client's particular position, and also the consequences of taking legal action. So the cost in terms of the financial cost of lawyers and experts, but also the kind of the reputational effect and the effect on the commercial relationship. So we've always tried to include that in the mix of the discussions that are taking place. I mean, I think that it's from my personal standpoint, when I am talking to clients at the moment, and I'm increasingly talking to clients because we're in a position where they have issued the original notices, so they've complied with their contractual obligations, and they're now looking at kind of the actual practical effects of COVID-19, so on the productivity on site, on returning to site, and how they're going to deliver those projects. And these discussions have tentatively are in progress. Some of them are tentative, and all of them are trying to remind each other of the kind of setup under the Cabinet Office and the Construction Leadership Council guidance. So, I mean, I'm hopeful that we will see it being referred to on an increasing basis by parties as time goes on, and as we start to kind of see what the true effect is going to be on site.
I think the other thing I'd like to say though is clarity. We've been asked a couple of times by clients, what use is this to me, or if it's just a non-statutory guidance and they can ignore it, how does it work? So I'm going to give you an example. A client managed at subcontractor level on public sector to have a large amount of retentions released. How? Political leverage. A very astute client, I might add, who used the combination of the PPNs, the guidance on both from Cabinet Office and CLC to say, aren't you, the other party, also a member of another trade body or and attached to it, who subscribes to this ethos? And therefore the conversation we're having isn't really in line with where we should be. There was no emotion in those correspondence or communications. It was simply, I guess, signposting to the relevant parts of information in order to say, now, therefore, can we have a conversation alongside the one we're having about contracts and who's got what risk, rights, obligations, in order to reach a settlement. It's very rare that, whether it be client, main contractors or anybody else, can truly profit from the demise of a supply chain. So when you add up the costs, regardless of whether you've got bonds, guarantees or anything else in place, and retentions held back, of sourcing an additional contractor, specifically during these times, it doesn't make economic sense. So I've seen some of the media talk from, let's say, a barrister's perspective about how unuseful some of this guidance can be. It has no binding effect in a court of law. No, it doesn't. The parties are, under the civil procedure rules, required to have followed a construction pre-action protocol. So that's a bit of a how-to before you start litigation. And it's also to have tried to, under Rule 1, to have tried to sort their disputes out amicably. Whether this would be picked up in that by a judge, I don't know. But the penalty for not trying to sort things out before recourse to litigation is that you can be penalised in costs. And obviously, adjudicators are free to go in whichever direction they choose. They may take this on board in slightly more detail. We've yet to see.
Yeah, no, I mean, I agree with that. I think it probably, if you are in a dispute with a particular party and you're finding that they're not being very accommodating, it might be worth, for example, checking whether they've signed up to the conflict avoidance pledge, which is on the RICS website. So if they've already expressed a commitment to try and achieve collaborative working and resolve disputes. Because if they've done that, that's something that you could certainly point to. But I take the point. I mean, what I'm finding increasingly is that part of the reason why clients and contractors are claiming that they want to stick with the contractual route is because there's a lot of anxiety about cash flow and the financial stability of the various entities that they're in discussions with, and obviously the public sector have dealt with this to a great extent by the issue of the public procurement notes, but there's been no equivalent in the private sector. So what I am seeing is increasingly parties are asking other parties to tell them about their financial situation, to kind of tell them what their real cash flow position is and what benefits they've taken from the government, so how many people they've furloughed, whether they've had any bank loans, etc., to give them that comfort that they're not just going to take the money and then not be available, not be around in a few months' time. So I think that's part of the anxiety of some people that are reluctant to follow this.
I also saw another webinar where one private practice lawyer said, don't compromise if it's more expensive. If you create more expense than you would via the contractual route, I think you've also got to weigh that up against the expense and time taken in litigation or dispute resolution.
Well, yeah, and the cost in terms of reputation and also in commercial relationships. I mean, there's lots of factors. Another factor that you need to consider, obviously, of course, is that there might be other stakeholders that need to have input in any arrangement that you make. So, for example, if funders are involved, you might need to get any settlement or any negotiated deal approved by funders. Likewise, insurers, because you may end up invalidating your policy if you enter into an arrangement that's not been rubber stamped green by them. And then also, you may want to look at the position along your supply chain, because if you agree something up the line, how's that going to impact on your position vis-a-vis your supply chain, and then obviously vice versa. So it's not just a case of having a discussion with the one particular party, it's about thinking about all the stakeholders and what input they may have or contribution that they may want to flag or raise.
So here's a bit of a shopping list of the issues you'll want to consider when hopefully you're reaching a point where you can actually seal some kind of deal in amending contracts. You want to obviously review your existing rights and obligations on both sides, and as Ruth described, maybe get some evidential backup and cost analysis around those. Please don't just shake hands on things without making sure they are recorded in writing and signed, or there's certainly an email evidence trail to identify that one party's put forward a position, it incorporates the elements from both sides, and that is unequivocally agreed to. The age-old problem in our industry, somebody comes back with, yeah, that's great, but, in which case it's a but, it's not quite an agreement. Ruth, do you think these things always need to be signed as deeds?
Well, if the underlying contract is a deed, then yes, it does need to be signed as a deed. If it's a simple contract, then you may be able to do it by way of just a simple letter. But one of the issues with letters is that in order to have a valid contract, you need to have something called consideration. So you need to be able to show that something has passed between one party to the other in exchange for the deal that they've struck. And if you have a deed rather than a simple contract, that does away with the requirement for consideration. So you might need to assess it on a case-by-case basis, but I think probably a deed would be the norm, and it would certainly save you some headache. I suppose the other issue to flag at this stage is although the initial, the lockdown is now easing, there's a lot of concern about possibility of a second spike, no doubt kind of compounded by sights of people on the beaches and whatnot at the weekend. And I suppose it's about trying to kind of think about, not about today, but about what might happen in a month or 2 months' time. So in a way, you need to think quite carefully about protecting your future position. So if you enter into an arrangement now, will that protect you in a month or two when there might be measures that you don't know about? So it's trying to address that. And one of the things that we've seen in some of the settlement, in some of the Ds of variation, are kind of an introduction of a more of an early warning type setup. So it's for the parties to continue to collaborate, and if something happens that might affect the delivery of the project or the cost of it, then they're to talk to the employer about it, and then they can discuss and agree the best way to deal with it. So it might be worth having a mechanism like that in there to allow you to deal with any future changes.
And I think that's where we wanted to give a bit of a picture of what goes in it. As PN 02/20 construction guidance has some model deeds of variation, JCT and ECA, but crucially, like all legal templates, it's the meat in the middle that will be missing, the nature of the deal, what it addresses. So these slides were really designed to just identify some key areas that Ruth's already touched on in terms of productivity rate, price. Do you want to change the nature of the price or the way the payment system works? Do you want to build in fluctuations where previously, and certainly in my professional career, I've never seen a single set fluctuations, anything other than taken out of the contract? How does entitlement to time and money work? Are we working under relevant events, relevant matters, or compensation events? Suspension, termination, and as Ruth said, the future proofing. How are we going to deal with any more spikes or any other pandemics, epidemics that follow?
Right, so as Rob said, we are kind of recapping a little bit what we did about on our talk a month or so ago. But just starting with the JCT form of contract, I think it's probably important that you have to consider each project on its own facts. So what is the actual practical impact of the coronavirus on the particular project? So is the issue relating to social distancing? Is it not having enough staff because they've been furloughed or not being able to get materials and equipment? And it's also important to recognise that what we've done in these slides is identify the wording of the standard JCT form by reference to the design and build contract, but it's very common for them to be accompanied by a schedule of amendments. So it's really important that you identify whether there's any clauses that have been amended. On this slide, I'll just quickly recap the provisions that might already be relevant to COVID-19. So what mechanism you've already got to either get an extension of time, a claim for loss and expense, put a question mark against loss and expense, because some of the basis for an extension of time, such as force majeure, for example, and government action, isn't also a basis for a loss and expense, it's a cost neutral item. I've flagged up that on a particular project, it may be appropriate for the employer or the contract administrator to either postpone the works, for example, to allow for the supply chain to get moving again for particular pieces of equipment or materials to be provided, or to give instructions to change the way that the method of working, or to use a different material if it's going to be very difficult for you to get hold of it. Of course, if there's an instruction, a change to the contract, you may be entitled to both time and money. Suspension of the works, we've seen there was no instruction by the British government to in England for sites to close and suspend, but of course we saw a number of construction projects being suspended, either at the insistence of the employer or the contractor. There's a mechanism under the JCT contract for works to be suspended due to force majeure, and there's a period which is usually 2 months, although it can be extended, and after that 2 months period, the contract can be terminated by election of either one of the parties. I think we're probably in the position now where the majority of people ought to have given the required contractual notices, particularly for delay under their JCT contract, and may even have updated those notices as we now move into this kind of second phase of operating under the site operating procedures. And also, as we've talked about, there's this scope to have these without prejudice discussions. This slide that's up now just lists the relevant events that might be relevant to what's happening at the moment. I flagged at the top that ordinary shortage of labour materials is not a relevant event. I flagged also that a change in statutory requirements after the base date, so that's the date stated at the outset of the contract, is often the date that the contractor gave his tender, can sometimes be the date on which work started. This can be a change which would entitle a party to time and money. The issue is that a lot of the changes that we see in the instructions from government, the guidance, the site operating procedures, etc., haven't really got the force of law. I've listed briefly the various heads of relevant events, so changes, variation, instructions, deferment of possession, impediment, prevention or default, exercise statutory power, and then the final one is force majeure, and a reminder there that that doesn't also entitle you to money. The next slide really relates to the giving of notices, and the notice of delay should be given as soon as it's reasonably apparent. You should comply with the notice requirements in the contract. Contractors, subcontractors have an obligation to use best endeavours to prevent further delay. Part of this process is no doubt going to be being able to show that you can comply with the site operating procedure, and of course the current version is version 4, but it may be over the past few months you've complied with version 1, version 3 and now version 4. Relevant matters, a reminder that they're not the same as relevant events. A reminder that about the definition of variations. As I said, it may be possible to agree with the employer that there's a variation, there's a change to the works, and that's an alteration or modification of the design, quality or quantity, or alternatively imposition of obligations and restrictions on the ways of working. The impact of this clause may depend quite a lot on in what environment you're working, whether you're doing a fit out contract, whether somebody else has got control over the site, or whether you've got control over the site altogether, and also whether or not you're doing the work indoors or outdoors, and how difficult it is or not to comply with social distancing requirements. We've talked briefly about the suspension leading to termination, which, as I said, is on the basis of either force majeure or statutory power, and if the works have been suspended for that period, then either party can elect to terminate. What I've seen quite often in relation to the contracts that I've been dealing with is that parties have been trying to extend that period if they can, and extend that period as part of any deed of variation. So the next slide, please, Rob.
So I just wanted to take you back over NEC, not in great detail. It's usually option A, which is the fixed price, or the bill of quantities of B, which is taken up. If you're in C, D, target costs, you'll have the ability to adjust price and share the pain or gain of COVID-19 impact. You have option X1, which is my signposting to you for inflation. So that's the equivalent to JST fluctuations system. And then options E and F will also allow you to manage the cost in different ways. So it's options A and B type of contracts which are most common, which I've already dealt with some disputes on within the context of COVID-19 impact. There is an equivalent clause for force majeure, but it's broken down into 3 tests. They're outlined there, and we've covered those in more detail on previous webinars. If met, that can give you a right to a compensation event, which actually allows you both time and money under the NEC system. And if that is prolonged, it will also give you the right to go into some suspension and termination provisions. Like Ruth said, with the JCT, make sure you serve your notices right on time. There are a couple of others on the bottom there about instructions, sequencing and delays, which will also give rise to compensation events. Why are we covering these in any great detail? Because we told you under the guidance, collaborate, but that is a concurrent conversation between having the contractual conversation, issuing the right notices on time. NEC specifically includes working in the spirit of mutual trust and cooperation. It has an early warning system, so you identify these things early. And in some forms where you have a risk register, you can touch on those too. But there are dead clauses. Those are bespoke amendments. So you've always got to be aware with JCT and NEC that things are usually amended. I know that one public sector infrastructure client has about 21 dead clauses at least. And so that kind of leads us back to the practical issues where we've touched on there. I know site safety resources and guidance out from the government, but that isn't law, so it won't necessarily lead to a contractual change in law. There's resource availability issues that you've got to consider moving forward. There are business support measures in place for the public sector, but not the private sector. You've got to work out your additional productivity rate. That will tell you what your costs look like and what mitigation measures you can put in place to manage that and manage the contract. When you look at what your losses are, it's got to be compared to what they could be if you go down formal aggressive dispute resolution routes. And as we've asked you before, make sure you continually do your contract audit. And this isn't just about where we are now, that's us moving into the future, as well as reserving your rights, getting your evidence lined up, photographic, video, site diary records, and all the rest of it. Collaborate on any kind of agreed suspension and solutions is the way this works. We just wanted to touch briefly on future proofing. So this is a clause which, thanks to Ruth's team at Clarkslegal, they put forward. And Ruth, feel free to interrupt me on any of it, but I'll try and explain some of it. So first, we start off with a definition, talking about COVID-19 pandemic and making sure that any mutation or anything else is covered between the suspected dates of its applicability to economic activity and construction crashing. It covers, I've underlined parts of this because it covers subsequent outbreaks of COVID-19. I've actually tinkered with the clause and made sure it covers other infectious human diseases, epidemics and pandemics, which I took actually from reading some of the business disruption insurance policies, where that wording was there for excluding COVID-19. It goes on to talk about measures, recommendations. So that's your government guidance, not just legislation and regulations, which are required to be implemented following the government or others. And then it talks about what you get. That's the clauses. So the notwithstanding any other provision that you see there means this one trumps any other provisions that might limit your ability to claim time, money, or anything else. And then the first clause there allows you the ability, if you're going to suffer disruption, to claim back time. Over to the next slide. Your second gives you the ability to claim back costs. And then I've stuck a third element in here, which is actually if the disruption continues over a cumulative period, which I've just used 90 days, but it doesn't matter what you want to agree, giving the subcontractor rights to flex if it needs to terminate or to mitigate its own commercial position. Now, I'm not saying you'll get away with any of this drafting. Everything has to be adapted. This is a baseline to start with in your collaborative discussions, and you should always expect to be negotiated with. So don't just add clauses in. You can add a catch-all clause, but you've got to consider how it links in with other clauses in the contract and make sure it overrides, matches with the other obligations. This is because force majeure only usually gives you time and not money, so we've gone down this road. And then what you can see with the work that's been progressed here, in terms of Anne's presentation earlier, is that it's dovetailed very much neatly with the key points that the CLC at its very high level were noticing and observing and setting up work streams of as it moved through the early stages of the COVID-19 period. And we saw patterns of behaviour within the industry of adversarial contractual behaviour that would be linked to large-scale redundancies and then insolvencies and other things that would systemically kick off in terms of compounding the economic recovery. So it's really great to see in the roadmap for recovery, collaborative business models, fairer payment and contractual models, and the procuring for value. So one thing I'd like Anne to tell us about is what she thinks that might look like in terms of moving forward. I did also want to touch on an announcement that came out of the government very, very early on from the Chancellor that they were going to amend insolvency law. We're starting to see what that looks like. Next reading was the 3rd of June. When it talks about avoiding stat demands dated 21st of March to the 30th of June, restriction on winding up petitions being issued between the 27th of April and the 30th of June. It talks about a company moratorium, not partnerships or sole traders, just companies, which meant that you can't start to enforce debts in between that lockdown periods. But the question I would raise is if this law very, very unusually gets passed and becomes retrospective, which it currently isn't, that could kick out a whole load of activity that we're seeing people try and queue up to leverage the usual legal redress to get their debts back, and that's suddenly unavailable or wiped out. It will only put back the problem, because once those periods expire, they'll all kick in again, but it will buy people some time. So there we are. Omar.
Thank you, Rob, and thank you to Anne and Ruth as well. Really interesting conversation there, shedding some light on some pretty complex questions that our members in the industry have. So we have overrun slightly, but we'll take a few moments to answer a couple of questions. Just a reminder that a full replay of this webinar, including the Q&A, will be available on our YouTube channel. And more information for ECA members and the wider industry is available at eca.co.uk/business-recovery. So over to the questions. We've got one from Chris Ellis. Chris says, we have a particular client who we have a contractual agreement with stating payment terms of 30 days, end of month, but this is regularly in excess of 60 days. They are our biggest client, but due to their size, it's sometimes difficult to engage with the right person to discuss. What guidance would you give, especially in times like these, where cash flow is so critical, to prompt them to paying according to the agreed terms?
Ruth, do you want to have a crack first?
Yes, of course. I mean, this is this tricky one, because obviously you've got the balance that you need to try and strike here between this being the biggest client and that ongoing commercial relationship, but also, of course, this unacceptable situation where you're getting paid almost twice as late as you are supposed to be under the contract. What you could do is go back to the right under the Construction Act to suspend your works on non-payment by the final date for payment. You have to issue a notice, a 7-day notice, saying that unless payments be made within that 7 days, then you will suspend your works. You can suspend all or part of your works during that period of suspension, and you can also entitle to recover the cost of remobilisation, etc. Quite often the threat of suspending works can be enough to get an appropriate person to pick up the phone to you and to talk to you about it and try and resolve it. So that's one method to do. I suppose if you can use that to start a dialogue, then you might be able to explore why payment's been delayed for a particular reason, and may be able to, for example, agree on a without prejudice basis a payment kind of plan. So, Rob, anything else to add?
Yeah, just very, very quick story. When I was in private practice as a solicitor, we used to have letters that would go out from the head of credit control outlining how a client wanted to or needed to pay their bill. In this case, if it was construction, it can outline, as Ruth suggested, the right to suspend, recover appropriate suspension costs, the right to claim back interest on late payment. It's usually default 8% on business to business, JCT's 5%, NEC's 3%. It can also outline that you've moved to adjudication if they don't move to pay you. So the combination of those threats is quite key to leveraging your position. The point in my story is that there was no head of credit control. It directed the blame elsewhere, because one of your key considerations, as Ruth outlined, is keeping the commercial relationship non-aggressive. And in the same context, our partners were wanting to ensure that commercial key clients stayed with us. So they really simply, and I've often said to clients, blame the lawyers, we don't mind being blamed. But if you don't operate those tools, those contractual tools on time, immediately you're paid late. All the time you're delaying, trying to make sure things operate in a commercial, non-aggressive way, you're also delaying your rights should that not happen.
Okay, thank you. We have another question, this time from Paul Antino. Paul says, if your client has clearly asked you to work in a different way or process to the tender, and the previous 9 months of working on sites, thus costing you money, do you have a right to make a claim? If the client doesn't accept these additional costs, is this deemed a change on contract and thus the subcontractor has a right to terminate?
We
Well,
can
you have
answer
to go.
this as
Sorry, you
we
go,
can
Rob.
answer this as lawyers, but I wonder if as a QS, Anne would have a view.
So, I mean, I guess it, to some extent, it depends where you are in the process. So, you know, if you are actually well established on site, that's very different to if you're sort of in the mobilisation period, for example. And I would imagine that you would have to actually legally demonstrate that there is actually an additional cost. I mean, because again, there's a requirement to mitigate. But if it's very clear that for some reason, and sorry, it also depends if it's, to some extent, if it's a public or private sector client, of course, if this is coronavirus related. But we have certainly had examples within our practice where the client has said that they want a particular type of social distancing put in place on site, irrespective of the site operating procedures, so a higher level. And certainly our interpretation of that was therefore a direct client instruction. And therefore, if there were costs associated with that or time delays associated with that, then that would have to be taken into account. So unfortunately, it's one of those, it depends. But I mean, if the client has specifically told you to do something and it's a proper instruction, then, you know, it should, it's a variation effectively, and it should be considered as a variation. So
okay, thank
certainly
you.
that's my take on it. I don't know, you know.
I agree.
Yeah, I'd agree. I think the only thing I was going to add is that I think you just need to make sure that if you haven't got it already, make sure that it's recorded in writing. So if they've not issued a formal instruction to you, they've just asked you on site to do X, or you've had a discussion, then you should be insisting that it's followed up with a formal instruction in writing, so that you don't inadvertently cause yourself a problem down the line when you're trying to prove that it is in fact a variation to the contract.
Okay, thank you very much, everyone. Thank you once again to Ruth, Anne, and Rob for hosting today's discussion, and thanks to the audience as well. Some great questions there. I'll mention once again that our YouTube channel will feature replays of all our webinars that we've undertaken so far at youtube.com/ECA Live. And for more information and guidance and materials related to business recovery, visit eca.co.uk/business-recovery. And thank you very much, everyone, and hope you have a wonderful day.
Thank you.